Good morning.
Good morning, everyone.
Good morning, Judge.
Good morning. Hope you all are doing well. We're ready whenever you all are.
They moved me to a call.
No,
Yeah.
when did we do that, last night?
Your Honor, whenever you're ready, we can start with position number 4 on SAP.
Okay.
Mr. Baker. Come on.
And it's my understanding that this is going to be a negotiated plea. Is that correct?
Good morning, Your Honor. That's my understanding as well.
Good morning, Mr. Walker. Thank you. And this Mr. McLean's case?
Bill. Let's see. Yes, Your Honor, this is a negotiated plea, number 4.
Good morning, Mr. Baker. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, yes, sir, Your Honor.
Thank you, Mr. Baker. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Nothing but the truth, Your Honor.
Okay, very good. Thank you, Mr. Baker. Mr. Walker.
Yes, Your Honor. The state's recommendation is 12 months to serve, 26 days, credit for time served, 13 days, balance probated with the conditions of an anti-theft course and a stay away from the incident location, which is the Piggly Wiggly, located at 230 on Cleveland Avenue, to run concurrent on both counts.
Mr. McLean.
That is a negotiated plea, Your Honor. Yes, I asked the court to accept the plea.
Mr. Baker, it's my understanding in case 23 CR 004908G, you wish to plead guilty to willful obstruction of law enforcement officers and theft by shoplifting. Is that correct?
That's correct, Your Honor. I plead guilty, nothing but the guilty, but I'm on Social Security, Your Honor.
Okay, okay. So just answer my questions, Mr. Baker, okay?
Yes, yes,
Are you under the influence of any drugs or alcohol this morning?
sir, Your Honor.
You've been represented by counsel there. Are you happy with his representation?
Yes, sir, Your Honor, but I never know that I was on Social Security, so far I can, know what I'm saying, probably be able to pay for my anti-course, classes and stuff like that.
Okay, I'm going to let you discuss that with Mr. McLean, and I'll talk to you about it when we complete the plea, okay?
Yes, sir, Your Honor.
You understand that you have a right to a trial by jury, and that by pleading guilty, you're giving up your right to a trial by jury?
Yes, sir, Your Honor.
Has anyone forced or coerced you to plead guilty?
No, sir, Your Honor.
Okay, I'm going to accept your negotiated pleas, Mr. Baker. So what I'm going to do for you, I understand what you're telling me. So you should be able to take that theft course relatively quickly, but I'm going to waive the first month of probation fees so that you can get that done. And then once you complete that class, I'm going to terminate the probation, okay?
Yes, sir, Your
So,
Honor.
All right, so get it done in the first month. It shouldn't take you that long, and then you won't be on probation anymore, okay?
Yes, sir, Your Honor.
All right, Mr. Baker, good luck to you, sir.
All right, I can be able to get out.
If you don't have anything holding you, you'll be able to get out when the jail processes you out, okay?
Yes, sir, Your Honor. I appreciate that, Eric Morrow.
You're welcome. Have a good day, Mr. Baker.
Your Honor, position number 8, 5 North.
Is this going to be an arraignment and a bond hearing?
Yes, Your Honor, it is.
Good morning, Mr. Goodwin. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Can you raise your right hand for me, Mr. Goodwin? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you. You have been charged in case 23 CR 004864G with battery. This charge carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Mr. McLean?
We do.
How do you plead, Mr. Goodwin? Guilty or not guilty?
Not guilty.
We will record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Let's see, Ms. Hardy, good morning. Can you give me Mr. Goodwin's history, please?
Good morning, Your Honor. This defendant has 25 arrest cycles in Georgia, a felony conviction in 2021 for aggravated assault. There are misdemeanor convictions in 2012 and 2015 for battery, family violence, 3 probation violations, and 4 FTAs. Nothing further to report.
Thank you. What's the current bond, Mr. Walker?
Current bond is a $3,000 surety. In addition to the history that pretrial just read, I'm showing that he's being held on a no bond on a felony probation violation case. And related to case 20 SC 175889, he also is being held on possession of a firearm by a convicted felon. That is 23 CP 220827. As I just stated, he's being held on a $3,000 surety bond in this case. The victim's name is Robin Goodwin. It is the defendant's sister. She advised a law enforcement officer that her girlfriend, and her brother were hanging out. And out of nowhere, he punched her in her face. He was arrested on this charge and was assigned this bond. I believe based on his history of FTAs, his current felony holds in his overall criminal history a $3,000 surety bond. It's more than reasonable.
I believe I set this bond at the SCA calendar. Mr. McLean?
Your Honor, he is asking the court to consider a signature bond or a $1,000 bond instead of the current $3,000. He believes he will prevail in each of the things that was mentioned that is currently pending, the probation revocation hearing and the gun charge, as well as this case.
I think he has bigger fish to fry, Mr. McLean. If he gets a bond on those other cases, I think you should seek modification of this bond at that time. So for now, I'm not going to modify the bond. Good luck to you, Mr. Goodwin. Who do we have next?
Next, Your Honor, we're going to go to position number 9, Mr. Rashad Hill.
This is going to be a negotiated plea.
It is.
Yes, good morning, Mr. Hill. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Can you raise your right hand for me?
Pick it up.
Can you hear me, Mr. Hill?
Yes, I can.
Okay, do you swear from the testimony you're about to give before this? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down now, Mr. Hill. Thank you. Mr. Walker?
Yes, the state's recommendation is 12 months to serve 34 days. Credit for time served 17 days, balance probated with conditions of MHET or a BHET rather, alcohol and drug evaluation with any necessary treatment, and an FBIP course. Stay away from the incident location, 2549 Black Forest Trail in Atlanta, Georgia, and no contact with the victim whose name is Tony Hill.
Mr. McLean?
Your Honor, that's his dad. He's on the video today on the Zoom. Tried to reach him yesterday. I understand from his dad's communications with other lawyers in my office, that he's not going to be living at home unless and until certain conditions are met. In the meantime, Your Honor, Mr. Hill plans to live with cousins. He asked the court to accept his plea.
Okay, and Mr. Tony Hill,
Yes, sir.
If you would like to address the court, now is your opportunity to do so. If you'll activate your camera, if you would like to, you don't have to address the court, but if you would like to, I'm happy to give you that opportunity.
Okay, activate my camera. Okay, I'm kind of old school with this. Okay.
All
Okay,
right,
good morning.
Good morning. I remember talking to you earlier, Mr. Hill, right?
Yes, sir. Yes, sir.
Okay,
I
and
love my son. And I want him to know that. And as painful as this is.
Hold on 1 second, Mr. Hill, give me 1 second. Can you raise your right hand for me?
Yes, sir.
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Yes, go ahead, Mr. Hill.
Okay, first of all, I love my son and I want my son healthy. My son has worked 2 jobs for 23, 24 years. He has been a great young man trying to do the right thing. He lost his job back in November, UPS, a very good job. His mental state has decayed to the point where him and I.
Hey, Mr. Hill, this is all being live streamed on YouTube. I don't want you to talk about anything relating to
Okay.
your son's mental health, okay?
Okay, I'm sorry.
And I do remember speaking with you at SEA. I believe that we did that for quite a while in a breakout room.
Sure.
And I remember everything that you told me at that time. What I want to know from and as I said to you at that point in time, that we would do what we could to assist with the issues.
Right.
It's still my understanding, though, that you don't at this point in time that you don't want him back in your household. Is that right?
Yes.
Okay, so we're not going to allow him to be back in your household during the pendency of this. Okay, anything else that you want to tell me?
Well, I just want to try to get him the help he needs. That's
Okay.
it. That's
All right.
it in a nutshell.
Okay, thank you, Mr. Hill. We appreciate you being here this morning.
Thank you.
Yes, Mr. McLean.
Yes, Your Honor, he does ask the court to accept his negotiated plea. Continued care will be part of what probation will make sure he gets.
Okay. Mr. Rashad Hill, it's my understanding that in case 23 CR 004832A, you wish to plead guilty to simple assault, family violence, and willful destruction of a law enforcement officer. Is that correct?
No.
I'm sorry. A yes? Was that a yes?
Yes.
Okay. Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated. Mr. Hill, let me see. Given what I remember about your matter, I am going to waive the first 3 months of your probation fees to help you get and stay on your feet. When you complete the terms of the probation, it'll go to a non-reporting status, okay? And you do understand that that you're not to have any contact with your father at this time. You understand?
Yes.
Okay. Good luck to you, both of you, Mr. Hills.
Thank you.
You're welcome.
Position number 11, Jackson.
This is also going to be a negotiated plea.
That's my understanding, Your Honor.
Good morning, Mr. Jackson.
Good morning, sir.
Good morning. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. Can you raise your right hand for me, Mr. Jackson?
Sure.
Swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, sir.
Thank you.
Mr.
Thank
Walker?
you.
Yes, Your Honor. The state's recommendation is going to be 42 days to serve, credit for time served 21 days, balance probated with the anti-theft course, and a stay away from the Kroger located at 4920 Roswell Road.
Okay. And I have a restitution down here, but you're not seeking restitution?
That is correct, Your Honor.
Okay. Yes, Ms. Adams?
Your Honor, it's my understanding that he's actually been incarcerated for 38 days. He's actually been in jail since July 14th, since the day of the alleged incident. I was not aware that the state would no longer be looking for restitution, but I'm pretty sure that Mr. Jackson is not going to object to that.
Okay, so anything further?
Nothing further, Your Honor. We just asked the court to accept the negotiated plea.
Mr. Jackson, it's my understanding that in case 23 CR 004913E, you wish to plead guilty to theft by shoplifting, is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No, Your Honor.
You've been represented by counsel. Are you satisfied with her representation?
Yes, I am, Your Honor.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, I do, Your Honor.
Has anyone forced or coerced you to plead guilty?
No, Your Honor.
I'll accept the plea as negotiated, Mr. Jackson. Let's see.
Thank you, Your Honor.
I am going to, when you complete that anti-theft class, the probation is going to terminate, okay? So the sooner you get that class, the sooner you get that class done, the sooner you're not going to be on probation, okay?
Yes, Your Honor.
And you know you can't go back to that Kroger, right?
Yes, Your Honor.
All right, good luck to you, Mr. Jackson.
Thank you very much, Your
Your
Honor.
Honor, briefly, I don't think it would matter, but I want to make sure we get the paperwork right. I know council mentioned 38 days, but I just want to make it known that Odyssey is showing 21 days. So
Yes, he was originally in a different jail before he was transferred over to Fulton County, I believe.
I just didn't want any mix-ups with the jail because I think they're going to go by what's on his booking screen. That's all.
Yeah, I mean, okay, I understood. It's
Okay.
still more than enough time. It's just that
Correct.
he hasn't been, it's just that he was arrested on July 14th and has not been out of jail since.
Okay, well, it's still time served, so,
Right.
all right, so thank you, Mr. Walker.
So we leaving it as 4221, Mr. Walker.
If that's okay with council or it's time served.
That's fine.
Okay,
Thank you.
all right, who do we have next?
Your Honor, we're gonna go to South Annex.
Okay, who do we have at the South Annex? Do we have someone there with this gentleman at the South Annex?
Your Honor, I represent, Mr. Jimmy McKinney. I'm not sure if that's him. And I also represent, I believe his name is Darrell Williams. I would need an opportunity to speak with them.
Okay, let me try to figure out who this is though, first, Ms. Adams. Is there anyone at the South Annex that can assist whomever's there? Okay, so we'll have to come back to the South Annex. Do we want to go to the Oconee Jail?
But he's off mute, no, Judge.
He's off mute, South Annex. They can put it back on mute.
Okay,
We can go to Oconee County Jail.
if somebody's at the South Annex, there's nobody there? Okay, thank you, sir. Who do we have at the Oconee County Jail?
Antoine Russell.
Antonio Russell. That's position number 14, Your Honor.
Thank you. And this is going to be an arraignment and a bond hearing.
Yes, Your Honor.
Good morning, Mr. Russell. Can you hear me okay?
Yes, sir.
Good morning. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, Mr. Russell. You've been charged in case 23 CR 004839C with willful obstruction of law enforcement officers, battery, and giving false information to law enforcement. Each of these charges carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Ms. Adams?
Yes, Your Honor.
How do you plead, Mr. Russell? Guilty or not guilty?
Guilty.
Oh, Wait a minute.
Do you want to?
Yes, Your Honor.
You want to speak to him, Ms. Adams?
Yes, Your Honor.
Okay. Can you call, do we have the ability to call the County Jail?
Yes, sir.
Okay, so Ms. Adams, if you'll call and speak with him, we'll come back to him.
Absolutely. If they can please leave the phone number in the chat.
Can we do that? Can we do that from the County Jail?
Yes.
Okay, thank you. I see that we might have someone with the gentleman in the South Annex. Do we want to go? I don't know who that is yet or whose client it is.
He's my client, Your Honor, but I would need to speak, well, I believe he's my client. I had two clients in South Annex and I was not able to meet with them. I'm not sure if that is Darrell Williams or Jimmy McKinnon, but I would need an opportunity to speak with the both of them.
Okay, so why don't you go ahead and speak? The County Jail's number is in the chat, so go ahead and speak with him. And can we go to a case? I see Mr. Murphy's on the line. If we can take his case, I see that Ms. McLeod is on the line. We can take her cases, or we can take a case of Mr. McLean's if he's ready. So.
You didn't say. You didn't say that.
Good morning, Mr. Murphy. Who are you representing today?
Judge, we were rescheduled for Brandon Ramos, 23 CR 004697E. I was in front of you, I believe, on Thursday, and we reset it for today.
Did Mr. Ramos make the calendar today?
He's on, I believe he's position 13, Your Honor.
Oh, okay, thank you.
Your Honor, we got to wait for an officer to get to that floor.
Okay, all right, thank you. We'll be with you, Mr. Murphy. Who can we take next?
Position 7.
And I believe this is Mr. McLean's case, is that right?
Yes, Your Honor, Mr. Dozier is now in negotiated plea. Your Honor may have seen that he announced and the statement out this morning.
Good morning, Mr. Dozier. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, good morning.
Thank you. Can you raise your right hand for me? Swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do, it is.
Okay, you can put your hand down. Thank you. Yes, Mr. Walker.
Yes, Your Honor, the state's the modified offer is going to be 12 months to serve 30 days, credit for time served 15 days, balance probated with the conditions of a SDET course, and to stay away from the MARTA station located at 65 Joseph E. Lowry Boulevard, and to comply with any and all MARTA suspensions.
Yes, Mr. McLean.
Your Honors, so let me make sure that he heard that. They did accept your request, sir, Mr. Dozier. So your probation will start right away and you'll have to report to 132 Mitchell Street on the second floor, okay? He'd asked the court to accept his negotiated plea.
Okay. And 3 South, if you can unmute for me. Thank you. Mr. Dozier, it's my understanding that in case 23 CR 004874F, you wish to plead guilty to 1 misdemeanor offense. Is that correct?
I do.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
I am.
You understand that you have a right to a trial by jury on this charge, and not by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, I understand.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated. Let's see. When you complete the terms of the probation, I'm going to allow it to go to a non-reporting status. So the sooner you get the SDET completed, the sooner you won't have to report to probation, okay?
Yes, sir.
All right, good luck to you.
Thank you, Judge.
You're welcome.
Yes, sounds like it.
Your Honor, can we go to position number 22, Mr. Wimby? I believe he's a conflict. He's 22 and 23.
Okay. Is this your case, Ms. McLeod? Good morning.
Good morning, Your Honor. It is my case.
And what are we doing with Mr. Wembley this morning?
The state has an offer, Your Honor, but it would not allow him to get out anytime soon. And I just wanted to talk to him about the offer. I haven't been able to do so yet.
Okay, so can I get you to call courtroom 2? And I'll give you that opportunity. Do you have the number?
Your Honor, I'll give Ms. McLeod a call. I'll call her from another phone.
Okay, thank you. I appreciate it.
Thank
Not a
you.
problem, sir. Your Honor,
Yes.
I was just informed that the Antonio Russell that's in Oconee County Jail is not the Russell that we need. So I'm going to try to locate the Russell that we do need. And I believe he's on another floor. If you can give me a few minutes to find him.
Okay, that's fine. Just let me know when you're ready. So Antonio, is Oconee, is that Antonio Russell, position number 14?
Yes, Your Honor. His name is Antonio Russell, but he's not Antonio Dewan Russell, the person who's named on the calendar. He has a different middle name and a different date of birth.
Okay, so do we need him this morning? Is he on the?
No, Your Honor.
Okay, so I guess we can dismiss the Oconee County Jail if is he on?
Yes, Your Honor.
Okay. So it's my understanding, Mr. Antonio Dewan, that this is not Antonio Dewan Russell that's at the Oconee County Jail. So Oconee County can be dismissed from this morning. I guess he needs to find out when his next court date is if he's not on this calendar.
Okay, thank you, Your Honor.
All right, thank you. And let's see, can we, while we're waiting, Ms. Adams, can you speak with whomever's at the South Annex, if that's your client?
I have one more client in courtroom 2 for Ms. Adams.
Okay, all
And
right.
it's going to be position 15 and position 16.
That's actually
Oh, that's McLean. I'm sorry, Your Honor. It's actually Mr. McLean.
Right, and that's ready.
Salazar, 15 and 16.
Okay,
Would you like for me to go into a breakout room, or do you want me to give them a call at the South Annex?
let me see which is easier for them. South Annex, is anyone there with you, sir? South Annex is,
Anybody there? Looks like
Is that-
someone.
Officer Milton, is that Officer Milton?
I don't
No,
think.
Mr. Baker. Go ahead, Steve.
Oh, okay, so would it be easier for me to place you all into a breakout room, or would you prefer Ms. Adams to call?
It's up to you guys.
Okay, let's put you into a breakout room then. So if we can put Ms. Adams's laptop into a breakout room with the South Annex, please.
There's
And you let me know when you're ready, Mr. McLean.
We're ready.
Okay, and this is Mr. Salazar, is that right?
Yes, Your Honor, 15 and 16.
Okay, and it's gonna be a negotiated plea, is my understanding, and a non-cross?
Correct.
Good morning, Mr. Salazar. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you. Good morning, Ms. Nemini. Is this your case?
Yes, Your Honor. Good morning.
Good morning. You can proceed.
The state's offered is 12 months to serve 63 days, credit for time served 63 days, $300 fine, 40 hours of community service, alcohol, drugs, evaluation, treatment, FVIP, VIP, and then merge count 2.
Okay. That's your understanding, Mr. McLean?
It is, Your Honor, it's VIP, not FVIP. But Mr. Salazar, did you need to ask the court to convert the $300 fine to 30 extra hours of community service, or are you gonna leave it at $300 fine?
I leave it at 3 months.
Okay, be forewarned that, in DUI cases, it's practically doubled. Thank you, Your Honor. That is the negotiated plea.
Okay. Mr. Salazar, it's my understanding that in case 21 CR 006260A, you wish to plead guilty to driving under the influence of alcohol less safe. Is that correct?
That's correct.
Are you under the influence of any drugs or alcohol this morning?
No, I'm not.
You've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, I understand.
Has anyone forced or coerced you to plead guilty?
No.
Okay, I'll accept the plea as negotiated, Mr. Salazar. Good luck to you, sir.
Okay, thank you, sir.
Thank you, Your Honor.
Okay.
You're right, sir.
Yeah, that's right. We know. Good, you can't.
In fact, from over there, I have a conflict coming up. Your Honor, can we go back to positions 22 and 23, Mr. Wimby?
Okay. Ms. McLeod, what are we going to do with your client this morning?
We're going to arraign him, Your Honor, and also see if we can get a change in his bond.
Okay. Mr. Wembley, good morning. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hands down. Thank you, Mr. Wembley. You've been charged in case 23 CR 004754E with battery, and in case 23 CR 004842E with battery family violence. Each of these charges carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusations, Ms. McLeod?
I do.
How do you plead, Mr. Wembley? Guilty or not guilty?
Not guilty.
Or your not guilty plea, your case will be returned to the division judge and you'll get notification of your next hearing date. Let's see, can someone tell me what the current bonds are?
Your Honor, he had a signature bond initially on the battery family violence, but that was revoked because he was arrested thereafter on the battery charge. And the bond on the battery charge is $2,000, and the surrendered signature bond, it says $2,500. So it seems that he's looking at a bond of $4,500 and for him to get out.
Okay. Okay, I'm being told that he had a $2,500, I believe that's $2,500 pretrial that was issued by Judge Law. I issued him a $2,000 good bond. What's the history?
This defendant has a total of 4 arrest cycles, no felony convictions, no misdemeanor convictions, felony convictions, or FTAs, probation violations.
And Ms. Nemini, or maybe Mr. Walker, can somebody explain to me why there's no offer on position 23?
Your Honor, he Mr. Walker can take it.
So I was on the phone with the victim, but I believe position 22 was a battery, but it was amended to a battery family violence. I believe Ms. Nimini did email the clerk's office to ask for that amended accusation to be pulled down. With that being said, as you know, your second battery family violence would be a felony. So we usually don't extend offers when you have two battery family violences on the same calendar.
Okay, so let me make sure so I have position 22 that occurred on 8/2/23, or allegedly 6.
And that was not a battery family violence, Your Honor, because I represented him on both. His first appearance in both of them. The second incident involved someone who he was unrelated to him and he doesn't live with them at all. It was someone helping him to move. That was the allegation, to move from the location.
Okay, so is position number 22 a battery at the present time? The charge?
That's according to the calendar, that's my understanding.
Yes, Your Honor.
Okay, and position 23 is a battery family violence.
Yes, Your Honor.
Okay, and I'm sorry, Mr. Walker. So I'm not understanding.
I could take a second look at it and then see if I can give an updated offer.
Would you please? I mean,
Yes, I would.
if we have him here today and if we've resolved that issue, I would
Is the
like to.
defendant's intention to to resolve both cases today?
We would like to if the
Okay.
state is making
Right.
an offer.
Okay, I can take a second look at it. That's not an issue.
Okay, thank you, Mr. Walker. I appreciate it. Okay, so Mr. Wembley, we're gonna come back to you, okay? And I'll allow your counsel to speak with you again once we get an updated offer. Thank you.
Good morning, Your Honor. This is ACDC. Before you is position number 6, Ms. Deal.
Okay. Good morning. Let's see. And this is going to be an arraignment, is that correct?
Your Honor, I believe that's Ms. Adams' case, and she's in the breakout room right now.
Okay, all right, so we're gonna have to hold for a moment.
Yes, Your Honor.
We can go to medical, Your Honor.
Okay, who do we have at medical?
This is as Lakey Lima, but I'm not sure of his position number.
George.
Let's head on more. Mr. Howard represents him.
And this is,
Mr. Howard's handling that case. I'm not sure if he's on.
He is. He's on. He was on.
right, I saw him earlier.
I know he sent me a text earlier asking if we can hold this to the end of the calendar. I could reach out to him via phone to see if he's ready. I believe we're gonna have to
Okay.
handle in the breakout room.
Okay. So we'll be with him as soon as we can. Is there anyone else that we can take either at in courtroom 2, or I see that we have another person there at ACDC. I don't know whose client that is.
She's position 20, and she's also for Ms. Adams.
Oh, okay, so we'll have to hold on that also.
Judge,
Yes,
Judge, it was my understanding before you came on that I have another client that's on the calendar by the name of Rashard Stevens. I was unaware of it, so I would simply ask if we can reset that. I believe I'm listed on one of his cases, and I was not aware of it. So perhaps if we could reschedule for next Tuesday, so it would give me time to go out to see him at the jail and address what additional things have transpired.
okay, I'm happy to, yeah, it's not a time, he's position 17 and 18. So you would like him rescheduled for the 28th, I believe, next Tuesday?
Yes, Judge.
Okay.
Or would that be the 29th? Judge?
29th, it's the 29th, you're right, thank you.
Yes, Judge.
Okay,
All
so
right,
position
duly noted.
17 and 18 will reschedule for 8/29.
Thank you, Judge.
Judge, that's 17, 18, and 19.
Oh, okay, thank you. 29. And have we done all of Mr. McLean's cases?
All but 10, number 10.
Okay,
Also, Your Honor, there was a person who's outsourced to Cobb County, whose last name is Ba, B-A, and we need to convey an offer to him.
okay. Okay, the court will be in recess until one of the attorneys comes back. Oh, there we go, Mr. Howard.
Yes, good morning, Judge. I'm logging back on.
Good morning. I understand that you're handling position 13, the Ramos case.
It's actually, I'm handling the add-on, Mr. Azlaki.
I have Ramos, Judge.
Oh, okay. So who do we have in medical?
I believe that's Mr. Aslaki.
Yes, that's Mr. Azlaki in medical.
Oh, okay. And
We can do a breakout with.
Yes, Judge, we can do a breakout for this one. That'd be great.
okay. And who do you want to be in that breakout room, Mr. Howard, Mr. Walker?
Well, just myself and Mr. Walker. His
okay,
parents, his parents are on the line as well. So I guess we could include them also.
Okay, so
I believe it's Miss Parisia. I don't want to pronounce
Yes.
the last name.
okay, so thank you. So if you can place the four of us into a breakout room, please.
Hey, Will,
Yes, sir. We had some difficulties on.
you may call it 22391.
You said two what?
22391.
32391.
22391.
22391. Give me a second.
All right, thank you.
Norris.
Go ahead, send it.
Hey, Shelton Stevens, what position is he?
Say it one more time, sir.
Shelton Stevens, what position is he?
17, 18, 19. Rashad Stevens.
No, yes, say Stevens. You said
Nah, Shelton Stevens.
Shelton.
Shelton,
North 200.
that's add-on 2.
Add on 2.
Yeah,
I don't like the way this camera making me look, big dog.
Yeah, his first name is Steven Shelton.
you said what now, Mr. Will?
I don't like the way this camera making me look, bro. I look like that dude in y'all corner. All right, I'll be
Okay, Mr. Ozaki, we've had the opportunity to discuss your case. It will be a $1,000 signature bond through the jail. You're going to be released to your mother to take you to the emergency room, and we have made arrangements for placement for you. So that will be the order of the court. Good luck to you, sir.
Thank you, Judge.
Thank you.
Okay, who can we go to now?
Yeah, courtroom 4 North, position add-on number 2.
And this is Mr. Shelton.
Yes, sir, Your Honor.
And who's representing Mr. Shelton?
Your Honor, I believe that's Ms. Adams' case. She's still in a breakout with
Okay,
You don't have to serve anymore.
all right, so Mr. Shelton, we'll be back with you, sir. Your attorney is disposed right now, so. Let's see, anyone else that we can take? Is Ms. McLeod back out of the breakout room? Guess not.
Your Honor, I am
Oh.
here. I do need to speak to my client again, Mr. Wimby.
Okay. Were you speaking with him on the phone, Ms. McLeod, or?
I was speaking to him on the phone.
Okay, so can we get Ms. McLeod to speak with Mr. Wembley again, please?
Yes, Your Honor. Ms. McLeod, I'm about to give you a call.
Thank you.
All right, so we'll be in recess until someone comes back with us.
And Your Honor, Mr. McLean is actually speaking with position 1 and 2.
Okay,
I believe he'll be done within a minute.
okay, thank you.
All right. Your Honor, whenever you're ready.
Yes.
Position number 1 and position number 2, Mr. Bob.
Okay,
Oh, 1, 2, and 3. My
and
apologies.
3. Okay, and what are we doing with Mr. Barr this morning?
This is negotiated plea, Your Honor, on 1, 2, 3.
Okay, very good. Good morning, Mr. Barr. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, ma'am. Yes, sir.
Thank you.
That's I'm sorry.
You're fine. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you can put your hand down. Thank you, Mr. Barr. Mr. Walker?
Yes, Your Honor, for position 1, the state's recommendation is going to be 12 months to serve, 133 days, credit for time served, 133 days, balance probated with an anti-theft course and a stay away from the Family Dollar store located at 2433 Delow Drive. And that's to run concurrent on all counts. Would you like me to give the recommendation for position 2 as well?
Yes, please.
Okay, in position 2, that's going to be 12 months to serve, 133 days. Credit for time served, 133 days, balance probated with the condition of another anti-theft course and a stay away from the CVS located at 895 Ralph David Abernathy. And position 3, the state's recommendation is 12 months to serve, 133 days, credit for time served, 133 days, balance probated with the condition of an FFIP course, no further contact with the victim, C. Milton, and a stay away from 2137 Chadwick Road to run concurrent on both counts.
Yes, Mr. McLean.
Oh, Your Honor, so the first 2 cases are theft cases, but the third is a DV case. And in that, Chadwick Road is the defendant's mother's address. Milton does not live there.
Okay.
Does not live there. So if it'd be all right for him to be around his mom, that'd be great.
There's no objection.
Okay, so
We can do no
See,
further
it's-
violent.
no, is that C Milton?
Crystal Milton,
Okay, so no further violent contact?
that's fine.
Okay, very good. Mr. Bach, it's my understanding that in case 17 CR 023173A, you wish to plead guilty to obstruction of a law enforcement officer, theft by shoplifting, and theft by taking. In case 19 CR 005192A, you wish to plead guilty to theft by shoplifting. And in case 19 CR 008224A, you wish to plead guilty to battery, family violence, and cruelty to children in the third degree. Is that correct?
Yes,
Are you under the influence of any drugs or alcohol this morning?
no, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, I do.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes,
Has anyone forced or coerced you to plead guilty?
no,
I'll accept the plea as negotiated, Mr. Barr. Let's see, in position number one, as soon as you complete the theft course, I'm going to have that case terminate. Position number two, as soon as you complete the anti-theft course, I'm going to have that probation terminate. And when you complete the FVIP on position number three, I'm going to have the probation go to a non-reporting status. So the sooner you get that done, the sooner you don't have to report. Okay?
thank you, Your Honor.
All right. Good luck to you, Mr. Barr.
So Your Honor, the point about the address on Chadwick, since Crystal Milton does not live there and his mother does, I'll be putting that down in my contact sheet to probation as his address to get mail at.
Okay, so it's going to be no further violent contact with his mother, Ms. Milton.
But I don't know what your mother.
And
No,
there's not-
Milton, I'm sorry, Your Honor, Milton is not his mother. That's my son's mother. That was his son's mother.
The victim is his son's mother, but I believe they reside at his mother's house is what.
No longer. They do not any longer live there.
So it's either way, it's no further violent contact and we can strike the away address.
Very good.
Okay, thank you, Mr. Walker. All right, good luck to you, Mr. Barr.
Thank you, Your Honor.
Your Honor, can we go back to position 22 and 23? Mr. Wimby?
Okay,
All right.
yes, Ms. McLeod.
Yes, Your Honor, I have spoken to my client and this is going to be a plea, a negotiated plea.
Okay. And I've already sworn Mr. Wembley in. And whose case is this? Oh, Miss Nimini. Would you go over the terms of the negotiated plea in position 22 and 23 for me?
Yes, both are gonna have the same plea. Is gonna be 12 months, serve 26 days, credit for time served 13 days, balance probate, FVIP, 40 hours of community service. No further contact with Mr. Darren Walker for position 22, and then it's a stay away from the 1537 Childress Drive Southwest. And then the only thing that changes for position 23 is no further contact with ZK.
Is that your understanding, Ms. McLeod?
That is my understanding of the state's offer, Your Honor.
Okay, anything further?
Nothing further, Your Honor, just to point out to the court that my client really has no convictions and he is the father of a child. He has a child that he takes care of. And he does have, he tells me that he can go back to when he gets out.
Okay. Mr. Wembley, it's my understanding that in case 23 CR 004754E, you wish to plead guilty to battery, And in case 23 CR 004842E, you wish to plead guilty to battery family violence. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the pleas as negotiated. Mr. Wembley, let's see, when you complete the terms of the probation, it'll go to a non-reporting status. So the sooner that you complete the terms, the sooner you're not going to have to report to probation, okay?
Yes, sir.
All right, good luck to you, Mr. Wembley.
Thank you, Your Honor.
Thank you.
You're welcome.
Your Honor, that concludes my business before the court today. May I be excused?
Yes, we appreciate your help today, Ms. McLeod. Have a good day.
Welcome, Your Honor. You too. Thank you.
Can we do Mr. Shelton, add on two?
Okay, now that we have Ms. Adams back, where would you like to go?
That's fine, Judge.
Can we go to add on two, Mr. Shelton?
Okay, and what are we gonna do with Mr. Shelton today?
Your Honor, Mr. Shelton, he's gonna plead not guilty, and I'm gonna request a bond for him. Also, too, I sent an email out with regards to the 2015 probation case. I have not heard back yet. And so I just wanted to put that on the record because the court did tell me last time he was on the calendar to go ahead and contact probation with regards to the violation, the 2015 violation probation case that he has pending.
Okay. Good morning again, Mr. Shelton. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video? Was that a yes?
You have to use the same words.
Yeah, I'm having a difficult time hearing you, Mr. Shelton. Was that a yes?
Could you repeat your question? I couldn't hear you. It's a lot of noise.
Okay, I understand, Mr. Shelton. We're doing this by video. Is that okay with you?
Yes, sir, it is.
Okay, can you raise your right hand for me?
Yes, I can.
Do you swear, affirm, and testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can put your hand down. Thank you. Mr. Shelton, you've been charged in case 23 CR 004813A with battery family violence. This charge carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Ms. Adams?
Yes, Your Honor.
How do you plead, Mr. Shelton? Guilty or not guilty? Do you plead guilty or not guilty?
Guilty.
It's my understanding that you were going to plead not guilty this morning, Mr. Shelton.
Not guilty.
Okay. We'll record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Let's see, do we have Mr. Shelton's current bond?
It is a $3,000 surety. As the court is aware, he also is being held on a probation violation for a battery family violence. On that probation violation, there is a no bond currently set. In this case, law enforcement was dispatched to 1175 Henry Road. They spoke to the victim, Ms. Cassandra Porter, who advised that the defendant and her were engaged in a verbal altercation when the defendant slapped her laptop and her phone out of her hand. They then began to struggle over the cell phone. At that time, he did throw her into a nightstand. She was treated on scene by EMS. We have made contact with the victim. She advised to our office that she is afraid for her safety and the couple does have a history of domestic violence. As I previously stated, he has previously been convicted for a battery family violence, which is why we submitted this case as a felony transfer. We are waiting to hear back from the DA's office for acceptance. With all of that said, we feel as though a $3,000 surety is more than reasonable.
Ms. Adams?
Yes, thank you, Your Honor. Mr. Shelton, although he does have that BOP from 2015, he has not been in trouble with the law since 2015. And so he is gainfully employed. He actually works for Classic Collision as a quality control supervisor, and he's had that job for about 3 years. He's trying to keep that job because when he was arrested back in 2015, he lost absolutely everything, Your Honor. And so in order to avoid that from happening again, Your Honor, Mr. Shelton is requesting a signature bond. He does have an alternate place to go, and that is with his godfather. The address is on Allegro Drive. And so that way he can stay away and he can go ahead and maintain his innocence. With regards to the facts that the state has provided based on what is inside of the arrest affidavit, although that's how it's stated in the affidavit, that doesn't necessarily mean that that's how it went. And with regards to that, Judge, Mr. Shelton would like to be able to have his day in court and try to, fight this case because it's not how it actually happened.
Okay, well, as for today, I'm going to leave the bond where it stands. If the case is not transferred to the DA's office, or if the probation violation hold is resolved, then you can bring him back at that time, and I will entertain modification, but not today. Good luck to you, Mr. Shelton.
Your Honor, can we go to South Annex? They have a 10 o'clock calendar that they're trying to make.
Okay, and who do we have at the South Annex?
We have both Mr. Darrell Williams and we also have Jimmy McKinnon.
Okay, and can you tell me who's before me now?
Yes, it's Jimmy McKinnon, Your Honor. This is going to be a not guilty with the bond hearing, please. Position number 12.
Okay, thanks.
Your Honor, this is position number 6, Miss Unique.
That's
No,
it.
no, we're at the South
South
Annex.
Annex. I apologize. I'm so used to saying South Annex.
Okay. Good morning, Mr. McKinnon. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, ma'am. Yes, sir.
Thank you. Mr. McKinnon, can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, Mr. McKinnon. You've been charged in case 23 CR 004835C with simple battery, family violence, and simple battery against a person who is 65 years or older or who was pregnant at the time of the offense. Each of these charges carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusations, Ms. Adams?
Yes, Your Honor.
How do you plead, Mr. McKinnon? Guilty or not guilty?
Not guilty.
We will record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date, Mr. McKinnon. Ms. Hardy, can you give me the history, please?
I take, matter of fact, Judge, I'm sorry, Judge. I take the plea deal.
Your Honor, I'm gonna have to speak with him again, so can we come back to him?
Okay, so I guess you'll have to, they have it's my understanding they're getting ready for a 10 o'clock calendar, so I guess we'll go ahead and let you go into a breakout room.
Or can we reset him until the next calendar, Your Honor?
Well, if he takes, is something going, it's my understanding that if he takes the deal, that it's a time served deal and
He has felony holds.
Oh, he has felony holds? Okay.
Yes,
When would you like to have him reset until?
we can have him reset until next week.
Okay, so that's the 29th, so 8/29. All right, Mr. McKinnon, I'll see you back here next week.
I can't take the plea deal, Judge.
We're going to give you the opportunity to speak with your counsel again, and if you want to take the plea deal next week, then we'll allow you to do it next week, okay?
Yes, sir. Thank you.
All right, so I'll see you next week.
All right.
You're welcome. So who else do we have at the South Annex?
Darrell Williams, Your Honor, he is position number 21.
And what are we doing with Mr. Williams this morning?
That's also not guilty with the bond, Your Honor.
Good morning, Mr. Williams. Can you hear me okay?
Yes, sir.
I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, Mr. Williams, you've been charged in case 19 CR 003499A with battery, substantial physical harm, and reckless conduct. Each of these charges carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusations, Ms. Adams?
Yes, Your Honor.
How do you plead, Mr. Williams? Guilty or not guilty?
Guilty.
It's my understanding, Mr. Williams, that you were going to plead not guilty today. You need to speak with your Ms. Adams. He's saying that he wanted to plead guilty.
Remember when we talked about it, you wanted me to try to get you a signature bond?
Yes, ma'am.
Okay. Yes, Your Honor,
Okay.
not guilty plea.
So you plead not guilty today, Mr. Williams?
Yes, ma'am. Yes, sir.
Okay, your case will be returned to the division judge and you'll get notification of your next hearing date, Mr. Williams. Ms. Hardy, may I have his history, please?
This defendant has 24 arrest cycles in Georgia, felony convictions, 1976 burglary, first offender treatment sealed in 76, 78, 80, 81 burglary charges, 2005 possession of controlled substance, 2010 possession of controlled substance, 2 FTAs and 2 probation violations, nothing further to report.
So nothing since 2010?
That is what GCIC is showing.
Okay. Yes, Ms. Nemini.
Yes, Your Honor. This incident happened July 13, 2017. The officers were dispatched at the location in reference to the dispute call. The victim, who I just heard has passed away, advised that she'd been staying with the accused over the night due to their intimate relationship. The defendant wanted Ms. Houston to leave his home, so he told her to leave, and when she disagreed, he began to push her out the door. The defendant then took a black object that looked like a gun, according to the victim, and struck her in the back of her head, and that's when she called the police. The officers observed a deep laceration at the back of her head as well as blood on her shirt. Defendant claims that the relations between the parties are just strictly sexual, and he didn't want her to stay with him because someone had just hit her prior to her coming to him. Just based on the facts of the case, the state believes $3,500 is reasonable.
And what's the breakdown of the current bond?
It's just $3,500 for specifically for the battery substantial physical harm. There's nothing on the reckless conduct, to my understanding.
Your Honor, the document that I have that was in Odyssey shows 1750 on each count.
Okay. All right, and what you're telling me, Ms. Nemini, is that the alleged victim is deceased?
Yes.
Yes, Ms. Adams.
Yes, Your Honor. With regards to Mr. Williams, the defense would be requesting a signature bond for him. Again, as stated by the state, he has not been in trouble since this arrest. As a matter of fact, he hasn't had any convictions since 2010. The complaining witness has since passed away. She was actually murdered about 2 years ago. So there's not an issue with contact. Furthermore, Mr. Williams has been in jail for about 84 days total. At some point he was working. And so with regard to this entire case, he was born and raised right here in Georgia. His one living sibling is still here. He's a 4-year-old man. And Your Honor, we're going to be requesting a signature bond. There's no evidence of him being a flight risk. He does not make very much money. And on top of that, you know, there doesn't show that he is in the habit of he hasn't been in trouble in quite some time. And so with that, Your Honor, we'll request a signature bond.
Okay, Ms. Adams, if you can convert the good bonds to signature bonds, the same amount through the jail. No drugs, alcohol, or weapons while out on bond.
Yes, thank you, Your Honor.
All right, good luck to you, Mr. Williams.
Thank you, sir.
You're welcome. Okay, do you all want to go to ACDC next?
That's fine, Your Honor.
Officer Milton, are you with us there? And Mr. Murphy, I guess they're still trying to round up your client, so as soon as they get him.
Good morning, Your Honor.
Good morning. I hope you're doing well, Officer Milton. Nice little run
Fabulous.
there. Who do we have?
Before you is position number 6, Miss Unique. What's your last name again? Dewey.
Okay, and this is going to be an arraignment.
Yes, Your Honor.
Good morning, Miss Dewitt. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, I do.
Good morning. Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you. You've been charged in case 23 CR 004949B with simple battery against a police officer. This charge carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Ms. Adams?
Yes, Your Honor.
How do you plead, Ms. Dewitt? Guilty or not guilty?
Guilty.
It was my understanding that you were going to plead not guilty this morning. Is that not the case, ma'am?
No.
Ms. Dew, do you remember when we spoke yesterday? You asked me to try to get you a signature bond. Now, if you want to change it to guilty, we can do that.
No, I would like it to be guilty.
Okay, Your Honor, then we're gonna change it to guilty. We did prepare for that, so we can just go ahead and move forward.
Okay. Mr. Walker?
Yes, Your Honor. 1 second. Let me shift gears here. The state's recommendation is 12 months to serve, 22 days. Credit for time served, 11 days, balance probated, and an 8-week anger management course. And we'll just leave it at that. The victim was a detention officer in the East Point jail, so.
Ms. Adams?
Yes, Your Honor. We request that the negotiated plea be accepted as negotiated. Actually, you know what, Your Honor, there is one request. We would like to request that her probation be terminated upon completion of her anger management class.
Mr. Walker?
There'll be no objection to non-reporting.
Okay. I was going to have it go non-reporting, actually. Is that fine with you, Ms. Adams?
That's fine, Your Honor.
Okay. Anything further?
Nothing further.
Ma'am, it's my understanding that in case 23 CR 004949B, you wish to plead guilty to simple battery against a police officer, is that, or detention officer, is that correct?
Yes.
Is that a yes?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No, I'm not.
You've been represented by counsel. Are you satisfied with her representation?
Yes, I am.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
Okay, I'll accept the plea as negotiated. When you complete the 8 weeks of anger management, the probation will go to a non-reporting status. So the sooner you get the anger management done, the sooner you won't have to report to probation, okay?
Thank you so much.
Okay, you're welcome. Good luck to you, ma'am. Who do we have next at ACDC? Or do you?
Next, we have position attorney, Ms. Strozier.
Okay. And this is also going to be an arraignment.
One moment, Your Honor. Yes,
Good morning, Ms. Strozier. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank
Yes,
you.
Your
Can you raise your right hand for me, ma'am? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, yes, Your
Okay,
Honor.
you can put your hand down, Ms. Strozier. You've been charged in case 23 CR 004901D with battery, family violence, and battery. Each of these charges carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Ms. Adams?
yes, Your Honor.
How do you plead, Ms. Strozier? Guilty or not guilty?
Not guilty.
We will record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. What is the current bond?
There's currently no bond, Your Honor.
Let's see, what's the history, Ms. Hardy?
This defendant has 7 arrest cycles, no felony or misdemeanor convictions, 1 FTA and 1 probation violation.
Okay, Ms. Nemini?
Yes, Your Honor. This incident happened August 2nd of this year at 2792 Sylvan Road, Apartment A. Officers arrived at the location and they were advised by Mr. Matthew White, who's the victim, that he was jumped and physically attacked by the defendant and her brother. And the defendant is currently the girlfriend of the victim. There were scratches on his chest, stomach, and back, as well as a laceration at the top of his head. Considering that she doesn't have a lot of cycles, but she does have a simple battery from 2001. And it looks like 6 convictions. Yeah, the state is thinking a hold without bond is reasonable, Your Honor. From my understanding, this isn't the first time that officers have had to come to this location and deal with these 3 parties.
I'm sorry, Your Honor, you were breaking up.
Said, I don't believe you can hold her without bond.
Yeah, yes, Your Honor. That's actually one of the first things I was gonna say. On misdemeanors, you're entitled to bond. So with regards to that, Your Honor, if I may?
Yes, please.
Okay, yes, Your Honor, the way that the affidavit was written does not tell the story correctly at all. With regards to my client, she in fact was actually breaking up a fight. My client, along with her boyfriend and her brother, were all arrested. It's not like it was a situation where somebody was just jumped. The home, the address of 2792 is where she resides. Apparently her brother and her boyfriend had been arguing all day and it came to a head and she tried to break up a fight, yet she was arrested. She has been working for Walmart for the past 2 years. And she has 2 children, one an adult child, another one passed away. She's born and raised in Georgia. Her family ties are here. And for the record, Your Honor, Ms. Strozier has not been in trouble with the law for 18 years. So with regards to this, Your Honor, we are requesting a signature bond.
Your Honor, I'll just interject just a tad, just considering that we have all the affidavits for each individual, Ms. Strozier, her brother and her boyfriend, all of them are conflicting. So I'm not entirely sure that she was breaking up a fight. To my understanding, she and her brother were jumping Mr. Matthew White because Mr. Matthew White and her were arguing and the brother jumped in. But again, I read all 3 incident reports, and from this specific case, and they all differ differently. So we can't assume that she didn't get her brother in to jump Mr. Matthew White in this case, Your Honor.
With regards to that, we can't assume that she did either. So with regards to that, Your Honor, we'll request it because it's unclear. And my client vehemently denies attacking anyone. We request that she get this bond.
Where did this incident allegedly occur?
It occurred at Ms. Strozier's home at 2792 Sylvan Road, Apartment A in East.
They all stay there allegedly.
Oh, okay. Now, is anybody, either of those other two people in their bond, did they get a stay away from that location?
I'm not entirely sure. I know Mr. Strozier took a appeal, and I think it was brought to the court's attention that he did not live at that location. So the stay away, to my understanding, the stay away wasn't presented, but there's information in both the incident report that Mr. Strozier, the defendant's brother, has been staying with them for some time.
He doesn't live there.
Okay, and what about Mr. White?
I'm not entirely sure about
Mr. White, I believe, does live there, but if I'm not mistaken, Your Honor, they're all still both in right here at Rice Street.
Okay. So, well, I'm not going to keep her away from her home, but I am going to keep her away from Mr. White. So the bond is, Ms. Adams, if you'll take it down, for the battery family violence, it'll be a $3,000 signature bond through pretrial per the judge. For the battery, a $2,000 signature bond through pretrial per the judge. Makes it a total of a $5,000 signature bond through pretrial. 1-day anger awareness. No further contact with Matthew White. No further violent contact with her brother, Mr. Strozier. No drugs, alcohol, or weapons while out on bond. Did you get all that, Ms. Adams?
Yes, Your Honor.
All right. Good luck to you, Ms. Strozier.
Thank you so much, Your Honor. Thank
You're
you.
welcome.
Thank you,
You're
Ms.
welcome.
Adams.
You're welcome.
Your Honor, we have Mr. Ramos, position number 13 in front of you, sir.
Okay.
Yeah, that's
Mr. Murphy.
There, Judge.
Yes, Mr. Murphy, can you remind me while we reset this?
This case had been on the calendar Thursday, unbeknownst to me. And I did not have the file, so we had rescheduled it for today. Your Honor, previously, Your Honor had set bond at $8,000 good bond. And I was to see my client, which I did. And I was asking the court to consider a signature bond under the circumstances. My client's still going to reside at 785 North Elizabeth Place, Northwest Atlanta, 30318. My client's been in custody 24 days. He's lived in Atlanta for over 10 years. His parents do reside in Georgia. They do not live in Fulton County. Your Honor, in that affidavit that the officer took, it had indicated that.
Mr. Murphy.
Yes.
Can you it's hard for me to follow because I don't remember the facts. So would you mind having, I'll have Ms. Nimini remind me of the facts if you don't mind. Are we going to arraign him today also?
I suppose we could do that, Judge, if that will be a better housekeeping matter.
Okay.
Yes, Judge.
Let me go ahead and arraign him, and then let me get the facts from Ms. Nimini, and then we'll move forward with your argument, okay?
Yes, Judge.
Okay, thank you. Mr. Ramos, good morning. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video? Speak up. I can't hear you, Mr. Ramos. Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down, Mr. Ramos. You've been charged in case 23 CR 004697E with reckless conduct. This charge carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Mr. Murphy?
Yes.
How do you plead, Mr. Ramos? Guilty or not guilty?
Guilty.
It was
Judge.
my understanding, Mr. Ramos, that you were going to plead not guilty today. Is that not the case?
Excuse me, not guilty. Excuse me.
Okay. We will record your not guilty plea. Your case will be returned to the division judge, and you'll get notification of your next hearing date. Ms. Nemini, what are the facts?
Yes, Your Honor. This happened July 30th of this year at 1990 Donald Hill Holloway. Police got a call from Mr. Pickett, who was the security guard, who said that the defendant was firing shots at him. Upon further investigation, it was discovered that the defendant was firing shots in the air, not at Mr. Pickett. An investigation included going to the location where the defendant admitted to firing the weapon and determining that neither party could actually see each other from where they were respectively located. The officer never found bullet casings and relied on the defendant's admissions. The two parties are former co-workers that were in a dispute earlier that day. Currently, Mr. Ramos has a DUI hit and run from 2018. And he's currently being held on bond by Woodstock Police. We believe that the $8,000 good bond is reasonable in this case, Your Honor, considering that he was firing a dangerous weapon around individuals and people. Yes, Your Honor.
Thank you, Ms. Nemini. Yes, Mr. Murphy.
Judge, initially, it had been communicated that allegedly this incident happened at a gas station. My client had a disagreement with Mr. Pickett at the gas station, but he did not produce a weapon, firearm, nor did he fire any shots at while he was at the gas station. And I think it says in the affidavit that allegedly the shots are fired from my client's residence, which is well over 1,000 feet away, and it's not within any sight line of the two individuals. So he certainly there was no attempt to fire at Mr. Pickett or anywhere near Mr. Pickett. There's an allegation that the weapon was discharged, and in the affidavit it says that my client admitted to that, but there was no direct encounter after he left the gas station. And again, there's more than 1,000 feet away from that gas station, and he certainly will stay away from there. And he'll enroll in a gun safety class and surrender the weapon. I know Your Honor had wanted that to be done, so that would be done. So we've asked the court to consider a signature bond under the circumstances.
And Your Honor, the officer also heard the gunshots over the phone. So it's not just the victim statement. And, you know, Mr. Ramos admitted to the things that are alleged to the investigator. I just wanted to put that on record as well. And bullets can travel 100 feet, 1,000 feet. Just because they're not within sight line of each other doesn't mean the bullet couldn't have caused even more dire consequences than we're presenting here today, Your Honor.
Judge,
Go ahead, Mr. Murphy.
Judge, as far as the Holden Woodstock, that's for an unpaid traffic ticket. And it's my understanding that as soon as it's paid, that there would be no hold. Again, Judge, I don't believe there was any shell casings found or anything along those lines, Judge. I'd ask again, considering the time he's been in custody and he has family in the area.
Ms. Hardy, could you give me his complete history, please?
This defendant has 3 arrest cycles in Georgia. The only conviction is the one that Ms. Nemini mentioned, the misdemeanor DUI and hit and run in 2019, 1 FTA, and then that hold for Woodstock.
And are you telling me that he can't make any type of bond, Mr. Murphy?
That is correct. The family's not in a financial position to afford that bond, Your Honor. And my client is going to, he has other marketable skills, so he's going to go into another line of work. He's no longer going to be in the security industry. And again, there's he has no other contact with this Mr. Pickett, and he'll certainly stay away from that location and anywhere near this alleged victim, Your Honor.
Okay. Do you have something to take it down with, Mr. Murphy?
I do, Your Honor. I'm ready.
He's going to get one opportunity. So it's going to be a $10,000 signature bond through pretrial per the judge. A gun safety class. No further contact with the alleged victim. Stay away from the incident location. Surrender any and all weapons. And no drugs, alcohol, or weapons while out on bond.
Duly noted, Judge.
All right. Good luck to you, Mr. Ramos.
Thanks, Judge. We appreciate the grace of the court. Thank you. That's all I have.
All right. We'll see you next time. Thank you. I'm sorry that you had to hold so long.
That's all right, Judge. Sometimes that's what defines my occupation. Thank you.
Have a good day. Who do we have next?
Position number 5, Mr. Chambers.
And let's see, where is Mr. Chambers?
He is approaching, Your Honor.
Oh, okay. And this is also going to be an arraignment.
Yes, Your Honor.
Yes, good morning, Mr. Chambers. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Excuse me?
I'm sorry, was that a yes, Mr. Chambers?
Yes.
Okay, can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you. Mr. Chambers, you've been charged in case 23 CR 004703F with disorderly conduct, willful obstruction of a law enforcement officer, simple assault, and criminal trespass. Each of these charges carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Ms. Adams?
Yes, Your Honor.
How do you plead, Mr. Chambers? Guilty or not guilty?
Guilty.
Mr. Chambers, I'm happy to let you speak with your counsel. It was my understanding that you were going to enter a not guilty plea. Do you need to speak with him, Ms. Adams?
I just have a brief question. Mr. Chambers, remember when we spoke, you wanted me to try to get you a signature bond?
Yes, ma'am.
Have you changed your mind and want to enter a guilty plea, or do you still want me
No,
to
I didn't change my mind. I'm just trying to end this as quick as way as possible.
Your Honor, I need a second to speak to him.
Okay.
I need to clarify what he wants.
Okay, and it is a time served plea, is my understanding. For North, can we you want to go into a breakout room?
That, or I can call. I don't know.
Listen, the way the cord is working, that cord is so sensitive. If you move the phone an inch or a centimeter, the internet connection and everything gets knocked out.
Okay, we'll put you into a breakout room, okay?
Your Honor, briefly, Attorney Adams, if your client is willing to take a plea today, I'll be willing to dismiss the criminal trespass and the obstruction.
Okay, I'll be sure to let him know. Thank you.
Okay, so if we can put Ford North and Miss Adams into a breakout room. Mr. McLean, are you going to be representing the DV bench warrant, or is that going to be Miss Adams?
That'll be Miss Adams.
Okay,
And Your Honor, I'll be handling the position 3 on the bench warrant calendar. If we have a moment to address that, it should be quick.
Oh, that's nice.
all right. Let's see, can someone, I only have one on my, good morning, Mr. Dodos. Can someone send me the
Yes, let me see if I find it.
Miss Champion, Miss Grace? Is it possible for someone to send me the updated, I guess, DV bench warrant calendar?
Yes, Your Honor, I'll send it to you.
Okay, thank you.
I just sent it, Your Honor, so I think you should have it shortly.
Okay, thank you. Okay, Miss Adams, where are we?
With Mr. Chambers. Yes, he's gonna go ahead and take a guilty plea, Your Honor.
Okay. And tell me again, Mr. Walker, what 2 cases were you gonna, charges were you gonna null pros?
So I will be null processing count 2, which is the obstruction, along with count 4, which is the criminal trespass. He
Okay.
will be entering a plea to count 1, which is a disorderly conduct, and count 3, which is a simple assault. The recommendation, which is to run concurrence on count 1 and 3, is 12 months to serve, 48 days. Credit for time served, 24 days. Balance probated with the conditions of a 6-week anger management course. No further contact with the victim, whose name is Desmond Carter, and a stay away from 74 Northside Drive, which is a Chevron, I believe.
76 gas station.
Oh yeah, gas station.
Okay. Miss Adams?
Yes, Your Honor, we just asked the court accept the negotiated plea. Yes, I'm sorry, and also 2, we also request that his probation terminate upon completion.
I'll have it go non-reporting. Ms. Adams.
Yes, thank you, Your Honor.
And 4 North, if you can unmute for me, please. Thank you. Mr. Chambers, it's my understanding that in case 23 CR 004703F, you wish to plead guilty to disorderly conduct and simple assault. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Completely.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Chambers. When you complete the terms of the probation, it'll go to a non-reporting status. So the sooner you get it done, the sooner you won't have to report to probation, okay?
How long am I on probation for?
You'll be on probation for 12 months, sir, but it will only be reporting probation while you are completing the 6 weeks of anger management, okay?
Yes, sir.
All right, good luck to you, Mr. Chambers. You're welcome.
Thank you, Your Honor.
Position number 10, Your Honor. Mr. Jackson.
Okay. This is also going to be an arraignment.
This was, you said position 10?
Yes, Mr. Jackson.
That's correct.
Yes, good morning, Mr. Jackson. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir, Judge Mom.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir. 100%.
Okay. Mr. Jackson, you've been charged in case 23 CR 002532E with simple battery family violence and battery family violence. Each of these charges carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Ms. Adams?
We do.
Mr. McLean? Okay. How do you plead, Mr. Jackson? Guilty or not guilty?
Not guilty, according to my visit with my attorney yesterday.
Okay, we'll record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date, Mr. Jackson. Is there a request for bond modification, Mr. McLean?
Yes, Your Honor.
What is the current bond?
It is $2,000 on the simple battery family violence, and it is $2,000 on the battery family violence. And the felony case, which is $5,000, there was some confusion last week. I believe the state believed that a felony was holding him in and said that he wasn't being held on misdemeanors when he asserted I'm only being held on misdemeanors. But it is actually correct because the only felony charge that has that case in Superior Court is an allegation that he had a pill. Well, this pill is going to be found out to be by the lab to be some kind of mint, and it's not a drug. So when that happens, everything will come together. But Your Honor, that Superior Court judge gave a signature bond on the pill. So the only thing holding him in is misdemeanors. And so the $5,000 bond on the other thing, of course, we can't address that today, but we can address the $4,000 bond on our 2 counts.
Can we start with the top and have Pritchard read the history, Your Honor?
Thank you. Yes, Ms. Hardy.
And this defendant has 7 arrest cycles in Georgia, beginning in 2020. The only conviction I was able to see was a 2021 misdemeanor conviction for battery. Nothing further to report.
And then, Your Honor, I'm also showing that he's being held on felony battery family violence 23 CP 217980. That is a $5,000 surety, and that is the same victim as Kira Shaw that is the victim in our case. In our case, law enforcement officers were dispatched to the incident location at 2367 Cascade Road. They spoke with the victim, who advised that the defendant, Mr. Deshaun Jackson, beat her with a broom and punched her several times. Based upon The other open case, and there is a history of domestic violence between the two parties, we feel as though a $4,000 surety bond is more than reasonable.
And the battery family violence that he has the 5,000 good bond on, when did that allegedly occur?
It happened subsequent to this case. Look at those warrants one more time. So our case happened in February and the felony happened in April. So 2 months after our case.
Okay.
And I will say, I believe he was booked on both cases on the same day and time, if that makes sense.
Right, thank you.
In addition, Your Honor, I would like to emphasize, because he has no felony convictions, he has no FTAs. And Your Honor, the notation I saw, if I'm correct, I hope I am correct, but I believe the notation I saw on book screen says that in the case, that is the Superior Court case, which I believe will ultimately become a misdemeanor. That case has a county-funded ankle monitor. And because of that, Your Honor, that's an additional assurance to society that he is fully going to be in compliance with all bond conditions. If Your Honor could give him a signature bond, or if Your Honor could see its way clear, even if not a signature bond, to lowering the bond to a total of 1,000 in this current misdemeanor CR case. But he will be having an ankle monitor as soon as he makes his bond. His family's trying to make his bond. Financially, we're trying to get the number down where they can do that and wear the monitor. He has a child he hasn't seen, and well, I don't mean to run on. Thank you.
Okay, so Mr. McLean, take it down. For the simple battery, it's going to be a $500 good bond. For the battery family violence, it's going to be $1,000 good bond, making for a total of a $1,500 good bond. He's to have the ankle monitor. He's to not have any further contact with the alleged victim. He's to stay away from the Cascade Road address. And no drugs, alcohol, or weapons while out on bond.
Okay, each point, Your Honor. Thank you.
All right, good luck to you, Mr. Jackson. Okay, let's see. Does that come? Go ahead.
I have one more person, Mr. Russell Antonio. We were advised that he was moved to another floor. I'm about to go to that floor right now to go get him, okay?
What's the name?
Russell.
Yes, Antonio Russell, Your Honor. Antonio Russell is my client. He's the gentleman. Remember, they had the, oh no, that we weren't on yet. They couldn't find him. They thought that he was somewhere else and he wasn't. And so we were waiting for the state. Remember, they had Oconee County on here. And
Right.
I'm
Okay.
waiting for my client to be brought down. Or
Okay, so we'll hold until Mr. Russell gets here. Okay.
I'll be right back, y'all.
All right, thank you. Let's see, do we have anyone here for the 11 o'clock calendar?
Yes, Your Honor, we have Ms. Taylor here for position 3 on the bench warrant calendar, if we could address that.
Okay, yes, good morning, Ms. Taylor. I'm Judge Eric Morrow. This is the DV bench warrant.
Good morning.
Calendar. Good morning, ma'am. Mr. Walker, I take it that Ms. Taylor missed a hearing?
Yes, and due to the age of the case, we were able to reach out to the victim with the help of Mr. Mr. Dodes. So we will be submitting a null prize.
Okay, thank you, Mr. Walker. So, Ms. Taylor, your case is going to be dismissed.
Thank you.
All right, you have a good day, ma'am.
You guys have a good day too.
Thank you. Let's see, do we have Ms. Daniels or?
Yes.
Ms. Daniels?
Yes, this is her.
Yes. Good morning, Ms. Daniels. I'm Judge Eric Marr. This is the DV bench warrant calendar. Who's representing Ms. Daniels?
That would be me, Your Honor. I tried giving her a call this morning, but I was not able to reach her.
Oh,
Okay.
I'm sorry, my phone, my phone is off. It'll be on this evening.
Okay, so we're gonna go ahead and put you into a breakout room with Ms. Adams then.
Okay.
Okay, Ms. Adams?
Yes, Your Honor.
5 North, what Ms. Adams? 200, Russell.
So if we can place Ms. Adams and Ms. Daniels into a breakout room.
Thank you for this.
And yes, let's see, Mr. Walker.
Yes, Your Honor, are we on position 2?
Yes, Ms. Daniels, I take it she missed the court date.
Oh, she missed a couple. So Ms. Daniels has a $3,000 pretrial release bond. The first court date that she missed was on June 26th of 2017. It was a jury trial with Judge Besson. A bench warrant was issued. About a week later, that bench warrant was set aside and her case was reset. She had another court date on February 26th of 2018 where she FTA'd in front of Judge Besson again. Considering that she had a signature bond through pretrial services, as the court is aware, it's the defendant's responsibility to update any change of address, also to report to pretrial services once a month while out on bond. And considering the fact that she's FTA twice, she's had one previous set aside by the court and she FTA yet again. And it would be my guess that she also is no longer reporting to pretrial services. We ask that this second bench warrant that was issued by Judge Besson is not set aside and she's remanded into custody.
Yes, Your Honor, with regards to Ms. Daniels actually was evicted from her home. And based on her financial situation, she had a choice to make. She either had to choose shelter or choose to pay for her classes. And so she opted shelter. She wasn't aware that she could hold her mail, so she didn't receive the notice about the next court date, which is why it was missed. She is now gainfully employed and doing much better because she has 2 jobs. And she actually is ready to go ahead and re-enroll into the family violence classes that she was already taking, start over. She just was waiting to see what the court decided today before she made payment to those classes. And so with regards to that, Your Honor, and she's fully aware that she must keep, because I just informed her that she must keep her address updated. And if she ever, God forbid, finds herself in a situation like this again, that she can actually get her mail and go retrieve it so that she doesn't miss court. And that she also remains in contact with pretrial services so they are aware of what's going on so that she's just not missing. With regards to that, Your Honor, I don't believe she's been in trouble since then. I mean, that was 4 years ago. And so we are requesting that her bench warrant be set aside. And she's given an opportunity now that she's in a much better space to be able to handle her case.
What classes was she required to take?
She at one time was in the diversion program, which she obviously no longer is in. She was given an opportunity to take FDIP. That did not happen. And whether she had the money for the classes or not, it's still free to report to court or pretrial or to call the court to let them know your situation. That obviously didn't happen. Perhaps that's why they set aside the bench warrant the first time, but she had subsequent court dates and she FTA'd even after the set aside, so.
And again, Your Honor, she didn't receive the notice after she was evicted. She didn't have access to her mail anymore.
She was given the opportunity, so I just want to get this straight. She was given the opportunity to go into diversion somewhere back in time and did not complete that?
It's my understanding she began it, Your Honor, but because of the fact that she was evicted and she needed to either pay for shelter or pay for the classes, she did not complete it. That is correct.
Okay, this case goes back to 2016. Have you discussed with her resolving this case?
Your Honor, actually, you know what? I have not. I do not have an offer from the state.
I would be glad to put one on the record.
Okay, and before I have a policy. My policy is to give you one chance. Regardless, everyone would have an excuse as to that one chance. If I did not follow my policy in regards to Ms. Daniels and allowed her 2 chances, then what's the point of having a policy? So I'm going to stick with my policy as far as not setting this bench warrant aside. With that said, this is a 2016 case. I think it should be resolved. so that Ms. Daniels can move on with her life. So I would like for you all to talk to see if, if we can get this resolved. And if that's the case, then we can. If not, then I'm not going to, I'm going to follow what my policy is. I'm not going to withdraw this bench warrant. So happy to give you all the opportunity to speak on this.
And I just put the offer in the chat to Ms. Adams.
Okay, so once you get that, Ms. Adams, if you'll, I want to, before you do that, do we have position 1, Aldo Bacarlo online?
I believe so, Your Honor.
Is that your case also, Ms. Adams?
Is not here. Position number 1.
Aldo is here.
Yes, good morning, sir. Give us one moment.
What number is that? No, they're giving me the-
Yeah.
I'm sorry, I was meant to say.
Yeah. She's online now.
Okay.
You want to talk to?
Yeah,
I need to-
ask the judge. I'm talking.
Can you call her? Because I actually have to talk to her.
Okay, are you going to be representing Mr. McLean?
Your Honor, I'll be glad to talk to her if I could have a few minutes to talk to her on the phone first.
It's Aldo and so he's here. So if you want me to put you into I don't think you have anybody in the courtroom with you. You want me to put you just into a breakout room?
Telephone's fine.
Okay.
Anybody in courtroom.
And yeah,
All
all
right.
right, just so we can clarify, because I looked at the set-aside request and it looks like a Mary Kay Bacallo filled out the form. I'm assuming that's his mother, but since she signed as his attorney, I just want to make sure that she's not both.
Okay, I'm a recent attorney, so I just became an attorney. So I've never done anything criminal, so I'm concerned about that, but the case really doesn't involve me. It just involves my son. So I
Okay,
would like to help him, but I don't want to mess it up.
Okay, so I'm going to give you him the opportunity to speak with Mr. McLean regarding this case, if that's what you all want to do. And so he'll give you a call. Can you place your number in the chat? So that he
Actually, it's
what?
Your Honor, if they just call me because it is a public number that we don't mind giving out.
Okay.
The circumstance is 404-612-2392. 404-612-2392. It'll ring right over here.
All right. Okay. All right. So you all go ahead and speak, and Ms. Adams will place you back into a breakout room with Ms. Daniels.
Okay, thank you. Your Honor.
Okay. And we'll be in recess until someone comes back.
Thank you.
You ready to proceed, Mr. McLean?
Yes, Your Honor.
Okay, I take it that Mr. Calio missed a court date, Mr. Walker?
Yes, Mr. Callio has a $2,000 signature bond. He missed an arraignment calendar in front of Judge Morrison on January 31st of 2023. It's the state's position, it's the defendant's responsibility, especially when they have a signature bond, to update any change of address and to make it to all court appearances. We ask that the bench warrant is not set aside.
Mr. McLean?
It's one of those common things, Your Honor, where the apartment number was not in the address. And so the reason he didn't get the first one was because the apartment number was missing. He did get the second time that it was sent because the mail person he just happened to have more mail that day. And so the mail person saw the name, and even though it didn't have an apartment number on it, stuck it in with his regular mail anyway and stuck it into the apartment mail. But Your Honor, I did discuss with him the methodologies in which he should never miss a court date. If he can check with the clerk, check with the daily report, and be sure to not mess up this lack of apartment number in the future.
Okay, it's this court's practice to set aside a bench warrant on one occasion, Mr. Calio. So I'm going to do that on this occasion. You won't get the opportunity for a bench warrant to be set aside if you miss any further court date. So you have to make sure that that your correct address is updated with the court at all times. So we'll set this one aside. Good luck to you, sir.
Your Honor, before the defendant is dismissed, since it was an arraignment that he missed, can we arraign him while we have him presently?
I don't have a copy of the accusation to answer any questions about what the elements mean. Okay, if you want to shoot one over here, it would be by
yeah, I can read it. It's on Odyssey. I can email it to you.
Let's see, I could sign in here, but or we could just do the arraignment later. I mean, is it really necessary today?
Okay, I'm going to give you the opportunity to do it at a later time. So, all right, good luck to you, sir.
Thank you.
You're welcome. So we're waiting on Miss Adams. What about, is this Chastity, Miss Chastity Riddick? Is she on the calendar today?
The main SAP calendar? Or?
No, she was the only one that I had on a bench warrant calendar.
I believe we.
Oh no, that was for a different date. Yeah, we've already done that.
Right, that was last week. That was last week. Yeah.
Okay. Let's see. So we still have to do position number. Well, one of the positions on the main calendar. I think that we're still waiting for North to get with us. While we're doing that, can we at least go over the calendar?
Yes.
Yes, sir.
Okay, thank you, Ms. Grace.
Position number one was position 1, 2, and 3 were pleased. Position 4 and 5 was pleased. Position 6 and 7 were pleased. Position 8, reset jail jury. Position 9 was a plea. Position 10, reset jail jury with an amended $1,500 bond. Position 11 was a plea. Position 12, reset 829 SAP. Position 13, reset further notice with a $10,000 pretrial per judge bond. We're holding on 14. Position 15 was a plea. Position 16 will be non-pros. Position 17, 18, and 19 reset to 829 SAP. Position 20, reset further notice with an amended bond of $5,000 pretrial per judge. Position 21, amended bond, reset further notice, 3,500 SOB through the jail. Position 22 and 23 were pleased. On the add-on calendar, position 1 will be reset to 921 competency with a $1,000 SOB through the jail bond. Position 2, reset jail jury. Any concerns, questions, or comments?
What was add-on number one's reset date was?
9/21 competency calendar.
Gotcha, thank you.
And Your Honor, if I could, I see two members from PAD on the line. Is there any way we could do a brief breakout with the public defenders and the two PAD representatives that we have on? If the court will allow it briefly.
It's fine with me.
I think it says Reese Pad and then a Cameron Johnson. If they're still there.
And which public defender, you gonna do it with the courtroom two or?
Well, if the PAD representatives are still here, it would be courtroom 2, but I'm not sure if they're,
Yes, I'm Reese. I'm here.
okay, yeah, courtroom 2 is fine.
Okay. Do the judge need to be in the breakout room?
Yes, please. I just want to
Okay.
have a brief,
That is me.
I see the
Okay, Ms. Adams, is there an announcement on Ms. Daniels? Excuse me.
Just realized that I was on mute, Your Honor. Yes, she's gonna be a plea.
It's been every other week since I've been,
So, Ms. Daniels, if you can raise your right hand for me. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can put your hands down. Thank you, ma'am. Yes, Mr. Walker.
Yes, Your Honor. The state's recommendation is going to be 12 months to serve 4 days, credit for time served 2 days, balance probated with the conditions of a FVIP course and no further violent contact with Mr. Larico Jackson.
Okay.
There's no objection, Your Honor. The defense accepts the plea as negotiated. We just have to put accepted as negotiated.
Okay. Ms. Daniels, in case 16 CR 013998J, it's my understanding that you wish to plead guilty to battery, family violence, and cruelty to children in the 3rd degree. Is that correct?
Yes, that's correct.
Are you under the influence of any drugs or alcohol this
No.
morning? You've been
No.
represented by counsel. Are you satisfied with her representation?
Yes,
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
yes,
Has anyone forced or coerced you to plead guilty?
no,
I will accept the plea as negotiated. Ms. Daniels, given the age of this case, when you complete the family violence intervention program, the probation is going to terminate, okay? So the sooner you get that done, the sooner you're not going to be on probation, and the sooner
Okay.
you can move on, okay?
absolutely.
All right, very good, Ms. Daniels. Let's see, do you have everything that you need from her today, Ms. Adams?
Yes, Your Honor, I do.
All right, so we're gonna, Ms. Adams will get you where you're gonna need to report to probation. So you need to go ahead and do that within the next 2 weeks or so, okay?
Okay,
All right, very good. Thank you, Ms. Daniels.
thank you.
Ms. Adams, do you have a deputy in there, someone with you that we can check on Ford North to see if they're gonna be back with us?
Did you ever find Mr. Antonio Rifle? No. What did he say? I just asked Deputy Morris, he went upstairs to check anyway. He's supposed to be 5 North 200. Nobody can seem to find him.
Okay, you want to reset them till Thursday?
Yes, please, Judge.
Okay, so we'll reset them for the 24th, 8/24.
He's not on 2 North, he's on 5 North. He's on 5 North. I know that. He's not on 2 North either, because he wasn't on 2 North yesterday. Okay.
All right, so hopefully they can locate them by Thursday.
Yes, Your Honor.
All right, very good. I think that's completes, I believe that completes both the 9 o'clock and 11 o'clock calendars. Is that right?
Yes, Your Honor.
All right, thank you all. If you'll get your paperwork in to Ms. Grace so that she can get it to me, I'll get it signed, and I'll see you all on Thursday. Thank you.
Okay, thank you, Judge.
All right, y'all have a good day.
I'm gonna go straight.